All right, we're on the record in the matter of residences on Penn versus Hassan, 2401429. And counsel, your appearance, please.
Joe Joseph for plaintiff.
Okay, and Mr. Hassan, please come up to the podium.
Come on.
Okay, and sir, your name for the record, please.
Hassan.
Okay, and so, counsel, you had an opportunity to meet with Mr. Hassan, correct?
Yeah, so Mr. Hassan claims he has a waiver from prior management and that he doesn't owe a balance.
I got a Friday.
Judge,
Mr. Hassan, I have to record the proceedings.
Yes.
Please allow Mr. Joseph to address the court, and then I'll give you an opportunity to do so.
Thank you.
Okay?
we're having difficulty, Judge, because every time I spoke, he decided he wanted to speak over me. So I wasn't able to get a lot of information other than he's disputing it based on some waiver that I don't have for my client. So I was going to ask for an adjournment so that we can look into this potential discrepancy. But as of right now, I have no information that would corroborate his claims.
Okay. All right, so Mr. Hassan did submit to the court a waiver of fees form. It says LR Management. And it says amount to waive. It has late fees on there, legal fees, rental adjustment, and then it says renewal. So it says $1,297 or and then renewal $113.24. And there's two different signatures on here dated August 29th of 2024 and September 6th of 2024. So this is something that we just received today, counsel, and Mr. Hassan arrived.
Okay, so I don't have a copy of that. I don't know if there's a way for me to get a copy. Obviously, it would be proper for him to provide us that directly, but if the court can email it to us or make it available on my file, I don't know.
Or you can ask for a copy from your client.
I will do that, but
I will also have Doreen email this.
okay, perfect.
All right. Because I don't know what you can see, even if it's uploaded on the file for my file. I don't know if you can view that. I don't know exactly how it looks from an attorney's perspective.
Okay.
So I will have Doreen email this to you and to Mr. Katz.
Okay, perfect. And then we'll just adjourn this a week or two, whatever works for the court schedule.
Okay, so Mr. Hassan, Mr. Joseph has not had an opportunity to review this. He doesn't have a copy of this. So what we're going to do is he's going to have a copy of this, and then we're going to adjourn this 2 weeks so that he can... Sir, let me finish. Sir, let me finish without interrupting me. And then that will give him an opportunity to review it. And then maybe you don't have to come back. Maybe you do, I don't know. But right now I'm going to adjourn it for 2 weeks. Okay. And if everything's been resolved, then you will get notification of that and then you wouldn't have to come back, okay?
Can I please hear me for a second?
Can you what?
Hear me for a second.
I will, but I just want to make sure you understand what's going on.
I do.
Okay, and so what would you like
But
to
you
do?
know, I should not be here. They thought I did not sign a lease. They never sent me a lease. And when I went to the office, they found out it's their mistake. I never got it. They put me on whatever you call the high lease because I did not sign it. When they found they didn't, then they have to. I've been paying on rent every time, all the time.
Okay.
They won't sue me before even they know that they never sent me a lease to sign.
Okay, and so that's why Mr. Joseph is requesting this matter be set for a second hearing.
They
So we can
wasted
look into
2 months
that.
of my time.
What's that?
They wasted 2 months of my time. I'm going every day to the office, do something while they keep, because it's fees. They sent me the first time $200. And I want them to them. They sent me, I have rent due. I said, why? I pay you every month. They checked, the 2 days later said, you never signed a lease this year. I said, last year when I signed, they said this is renewable every year on automatic renewable. And I never got nothing after that.
Well, it's possible with the change in the management system, sir.
And I'm paying for it.
Something got switched out. If you have an issue with that, then contact, take it up with the property owner, the property management. So let's set this for September 24th.
Okay.
Does that work?
Yeah, Judge, what time?
Let's do 9 a.m.
Okay, very good. Thank you.
And again, sir,
What day, 24, what day?
September 24th is a Tuesday, it's 2 weeks from today, and it's at 9 a.m. If everything is resolved, then you shouldn't have to come back.
That's what I told me Friday, you're done. We're gonna send this to the lawyer, but just go in case, anytime you have a court,
Okay,
you have to be there.
did you send this to the lawyer?
No, they said gonna send it to the lawyer.
Okay.
They told me to talk to him in the morning before I see you. I talked to him, he had no news.
Okay, well, Mr. Joseph is covering for the attorney of record.
Yeah.
So maybe the attorney of record did not send it to Mr. Joseph? I don't know.
They sent him to sue me immediately, but they don't.
Okay, sir, I can't speak to all that, so, all right, we'll see you back on the 24th at 9 a.m., okay?
Thank you.
Have a good day. Let's go off the record. Okay, and then, Mr. Joseph, now you can go back in with Ms. Carter.
Thank you.
Yep. Okay. Go!
Now go.
Let's go on the record in the matter of Bethany Curtis, 24315. And counsel?
Good morning, Your Honor. Chris Buscemi, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
All right, thank you. And Ms. Curtis, your name for the record, please.
Bethany Curtis.
All right, and so Ms. Curtis is on probation for loitering or drugs or kept, used, or sold. And there was a probation violation that was held on June 20th, and then another one on August 20th. And on August 20th, this court, as a result of Ms. Curtis's plea of guilty, sentenced Ms. Curtis to 30 days jail and suspended it. The court ordered her to test that day and also to increase testing. And so now we are here because there is another alleged violation that Ms. Curtis tested positive for cocaine on the date that this court ordered her to test her court date, August 20th. And then we're here for the jail review as well. And so, counsel?
Yes, Your Honor. I had opportunity to discuss the matter with my client. She will not be contesting the violation. I'd just like an opportunity to allocate on her behalf.
All right, ma'am, please raise your right hand.
I do.
All right, ma'am, you heard the allegations, correct?
Yes.
And as to those allegations, how do you plead?
Guilty?
You also understand by entering into a plea the possible penalty as a result of your plea.
Yes, I do.
And the recommendation in this matter is for probation to be revoked, the case closed without improvement, $50 probation violation fee, 30 days jail from the jail review, plus 15 days from this matter, and your jail to be served in a treatment facility. Do you understand that that's the recommendation?
Yes, I do.
Knowing all that, do you want to continue with your plea?
Yes, ma'am.
I'd like to direct your attention to a test that was that you were told to take on August 20th, 2024. Did it reflect the use of marijuana and cocaine?
Yes, it did.
Satisfied, Your Honor.
The court has satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Technical violation number 5 will enter. And counsel, add to the recommendation.
Your Honor, as the recommendation, I will note that my client was ordered to take a test that day when she had originally come for a violation for the jail review. Now, she indicated that since this test, she tested on September 1st, and she has a test scheduled for today. I'd ask for a 1-week adjournment. I'd be curious to see, per her statement, that her THC level has gone down, that she will absolutely have nothing else in her system. And I saw what the recommendations are, Judge. I don't know if a week would really dissuade the consequences, it would sidestep the consequences immediately, but maybe provide the court with a little option for leeway based on some of the better steps she's taken in the last 2 weeks. So that's all I would be asking for is a 2-week. I'd ask for sentencing to be put on a week from today.
Okay. So this court, on the three prior violations were positive for marijuana. This one is positive for cocaine. The first violation also is marijuana. So now not only is so the marijuana levels, let's see here. The marijuana is not obviously part of this violation because that was the one that from August 20th. Also on August 20th, this court ordered mandatory jail for any future violation. And so while it appears as though the marijuana levels have reduced because it doesn't have a level, it just shows presumptive positive, now there's cocaine that's appearing in her system. So quite honestly, counsel, I don't see 1 week adjournment or to set the sentencing for 1 week is not going to dissuade this court from sending Ms. Curtis to jail because this court ordered on August 20th as a result of her plea to violations 2 through technical violations 2, 3, and 4, mandatory jail for any future violation. And this court even gave Ms. Curtis the benefit of suspending her jail of 30 days at the last hearing. And so now Ms. Curtis is now tested positive for cocaine. And so this court is going to proceed with sentencing today.
That being said, Judge, I saw that there was a recommendation, 30 days jail from the jail review plus 15 to be served, tethered to a testing, to some sort of facility. I asked for consideration for opposed to going directly to jail to potentially being tethered immediately to a facility. And that being said, we understand the discretion of the court. Thank you, Your Honor.
All right, thank you. Ms. Curtis.
Yes, ma'am.
If I recall correctly, you and your husband were arrested together and your daughter came and bailed the two of you out, correct?
Yes, ma'am. She bailed me out. My husband sat until he got PR'd from the court.
Well, no, he sat until he had a tether because he had many warrants for his arrest.
You're right, ma'am.
And the drug of choice at that time was cocaine as well. You have your child who believes in you and she posted bond for you. And now here you are violating with the same drug that you were charged with. And
Ma'am,
have you cleared up your warrant out of Taylor? Have you cleared up your warrant out of Taylor?
I just paid that off this morning.
Okay, very good. Okay, I'm sorry, you wanted to say something to the court?
I have also paid my daughter back on all of that, and I am down to $800 on the fines for Wyandotte.
Okay, and well, that's commendable, ma'am. That doesn't tell me anything about why you're continuing to use cocaine.
And I did not know that that was even in my system, as I have told my probation officer and my lawyer. It must have been in something I smoked. I have not used cocaine since I got out of jail.
Ma'am?
Yes.
Are you buying your marijuana off the street?
I smoked with a friend of mine. Well, I thought they were a friend of mine.
Which you don't have a medical marijuana card, nor do you have permission to smoke marijuana, which,
I understand that.
Just one moment, because what's interesting, ma'am, is you're telling this court you haven't smoked marijuana, or you haven't used cocaine, and then it must have been something that you smoked. So let's do this. On July 2nd, July 9th, and July 23rd, it indicated marijuana, okay? And then, so the court violated you for that. And and then the court ordered you to test on the 20th of August. So now we're talking a month later. And now there's cocaine showing up in your system and trace amounts of marijuana, which would lead one to believe that you haven't been smoking marijuana for you to have cocaine in your system, because it doesn't stay in there for 30 days, ma'am.
Ma'am, I told you in court that I had been smoking marijuana.
I know that. That's why you were in court for your probation violations, ma'am. When was the last time you used marijuana, ma'am?
Before court last time.
Regardless, ma'am, there's cocaine in your system, You're not supposed to be using any alcohol or drugs that are not prescribed. This court's going to order you to serve your 30 days jail. The court's going to revoke your probation because you're not listening to what the court says anyway, ma'am.
Okay.
And then the court's going to also order an additional 15 days, so you have a total of 45 days.
Okay, can I get time served from when I originally got arrested?
No, ma'am. This is all new. No.
Okay, when do I have to turn myself in?
Tonight.
And what about the money paid for chemical?
Okay, and I paid on chemical awareness classes already that have not started. What about that?
When you get out, then you can contact Miss Shaw and she can give you the information regarding that.
Okay, thank you.
The court will note that you can be tethered to a treatment facility through the Wayne County Jail.
Okay.
Go on the record in the matter of the City of Wyandotte versus Brian Overdorf, 241308. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. Mr. Overdorf, your name for the record, please.
It's Brian Overdorf.
All right. And counsel?
As the arraignment will wait formal reading, my client stands muted.
The court will wait the formal reading and to plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on September 18th at 10:15 a.m. And counsel asks to bond for your client.
Your Honor, I don't believe that my client has any priors, not on probation or parole. He indicates that he stayed with his mother in Detroit. He has a strong family support system. Financially right now, he would have a difficult time posting anything. I know that he received some state assistance through a bridge card. So I'd be respectfully requesting leniency when determining an appropriate bond based on my client's lack of criminal history and the charge that he faces himself with today. Thank you, Judge.
Okay, thank you. So, sir, tell me about your matter from Saturday in Dearborn Heights. What's going on with that?
I was in my grandmother's house and she was, we had a little disagreement or whatever, and yeah.
Okay, well, it shows that you're charged with dangerous drugs.
No, that's my medication. I didn't even see that ticket or whatever charge.
Sir, what was your medical emergency?
I haven't had my medication in a couple of days and I've been dying without it.
What's your medication, sir?
Suboxone, Xanax.
And so you found it necessary to take an ambulance to the hospital for that?
That's ma'am.
Why didn't you go to your doctor, since you've been without it for a couple of days? Why didn't you go to your doctor?
I had an appointment Monday, but I was incarcerated, so I missed it.
Oh. If you were to test today, sir, what's in your system?
Nothing.
All right. And have you ever failed to appear in court for any reason, sir?
No.
All right. And you don't work? Why not? Why don't you work, sir?
What's that?
Why don't you work?
I don't have a car right now.
I'm sorry?
I don't have a vehicle right now.
You don't have a vehicle. Okay, you don't know how to send your rides or walk to work?
Say that again.
I'm sorry?
Say that again.
You're telling me to say it again? That's how you're talking to a court?
But I don't have a vehicle.
I think you've missed some of my communication, sir. So why don't you walk or learn how to find some rides?
I don't know. I just went for an interview and I was supposed to start on Thursday, so I was gonna figure it out.
Okay, and so where's that?
Metal roofing company.
Okay. Well, All right. Sir, you have a drug charge from Saturday, and now you have this trespassing charge from, this morning. And so, here's what the court's going to do. Are you on probation or parole, sir?
No.
Do you have any other pending matters other than the, Dearborn Heights matter? Sir, do you have any other pending matters?
No, ma'am.
Other than the matter in Dearborn Heights?
No, ma'am.
Wow. Okay.
I said it 3 times, sorry. Thought the thing was broken, I don't know.
Sir, I'm not sure really who you think you're speaking to, but I'm
I'm
not
on
one of
TV
your
screen.
friends.
Sorry, I apologize.
I'm
No,
not
listen
one of your friends that you're gonna talk to like that, sir, I can assure you that. All right, based upon the nature of the charges and the fact that Mr. Overdorf is currently out on bond in another jurisdiction, the court's going to order a $2,500 10% bond. In the event bond is posted, you are not to enter the premises under Fort Minot Hospital. If you have a medical emergency, sir, then you need to be directed to another hospital.
They were supposed to take me to another hospital, that's the whole thing. But you already stated what you stated, so it is what it is.
Well, I haven't been able to finish what I'm stating because you've interrupted me again. So, the court's going to note, sir, in the event there's a life-threatening emergency and the ambulance is taking you there, that's one thing. But going to Henry Ford Minot Hospital for medication refill.
It wasn't for a refill, ma'am, but I was having seizures and stuff, so it was more than that.
Okay. But just so you are aware, sir, you can direct the ambulance to take you to a certain hospital if it's still within a certain distance.
I told them to, and then.
You're not supposed to consume alcohol or drugs unless prescribed. And then we'll see you back on the 18th. Thank you.
Thank you.
The record of the matter of the City of Wyandotte versus Tara Juilliard, 241307.
Good morning, Your Honor. Chris Trashemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Thank you. And Tara, your name for the record, please.
Tara Marie Juilliard.
All right, and counsel as to the arraignment.
Wait, formal reading. My client stands mute.
Court will waive the formal reading and certainly of not guilty for purposes of the arraignment. And as to the pretrial, the pretrial date will be September 18th at 9:45 a.m. And as to bond counsel.
Your Honor, as to bond, my client's 43 years old. Right now she is on disability for MS, and that's my understanding that she lives with her dad. She has a strong family support system. We don't see any prior convictions, so we'd be respectfully requesting leniency when determining an appropriate bond. Thank you, Your Honor.
Okay, thank you. All right, ma'am, and you don't work?
No, I'm a disability, disabled.
Okay, and if you were to test it again, what's in your system?
I'm sorry?
If you were to test today, what is in your system?
It would be the Norco and Adderall, which I'm prescribed by my doctor.
Anything else?
No, ma'am.
And you prescribe both medications from your doctor?
The Norco and the Adderall.
Okay, and so you don't live at the address in the police report in Dearborn Heights, you're in Trenton?
No, I'm in Dearborn Heights.
Oh, you are in Dearborn Heights, okay. So, here's where the Trenton comes in. What happened to your matter from May in Trenton? Did you appear in court?
What was that? I'm sorry, it's hard to hear.
What happened with your matter in Trenton back in May. Did you appear in court already?
I go Thursday morning.
And what is that charge?
Paraphernalia. They have me do random drug testing.
Okay, so ma'am, let me just understand this for a moment. You have MS, correct?
I'm sorry?
You have MS, correct?
Okay, it's breaking up, but it's hard to.
Do you have MS, is that correct?
Yeah, sorry.
Okay, well, I'm going to presume that some of these medications are not necessarily helpful, or some of the substances that you are being charged with between this case and the 33rd District Court are not helpful for your condition, ma'am.
I have multiple illnesses. That was just the main one. I have a degenerative disc disease, which I have like 8 herniated bulging discs from my neck to my tailbone as well. And then ADHD.
All right, this court's going to order you, ma'am, the court's going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs unless prescribed, and you are to submit to random testing. You are to stop at the probation department upon release.
Okay.
You get set up with your testing.
Okay, thank you.
Ma'am, let me be very clear. If there's a bond violation, it's possible that you will be incarcerated.
Okay,
Quite possible. We'll see you back on the 18th.
thank you.
Alright, once they're done with their paperwork, we'll release you for the next go to probation.
All right, and we are on the record in the matter of the state of Michigan versus Canisia Williams, 241309. And detective, your name for the record, please.
Morning, Your Honor. Detective Joseph Carr, Wyandotte Police. Close it.
All right, and we're going to have to do it again. You solemnly swear that the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. And,
Your Honor, on September 8th, about 1 p.m., officers reported they identified a stolen vehicle identified as a green 2018 Jeep Renegade bearing Michigan plate EMA in the area of 4th Street in Eureka. Officers followed the vehicle where DCD confirmed that the vehicle was stolen out of Detroit. Wyandotte officers initiated a traffic stop in the area of Fort and Quarry with surrounding agencies assisting. Officers blocked the vehicle in and attempted to make contact with the driver, later identified as the defendant, Canisia Williams. The defendant refused to unlock the car doors and refused to comply with all officers' verbal commands to exit the vehicle and open the door. The defendant then accelerated and struck a fully marked patrol vehicle and then led officers on a vehicle pursuit northbound 4th Street at speeds greater than 80 miles an hour. Officers reported that the Jeep Renegade was soon located unoccupied in a parking lot located at 3807 4th Street. The defendant and her passenger were subsequently apprehended and arrested in the backyards of 3922 22nd and 3914 22nd. The defendant driver was cited locally and released. During a recorded interview with the defendant and under Miranda, she admitted to fleeing from the police on the time and date indicated, including a previous fleeing and looting incident that took place in Lincoln Park in the same vehicle a few days earlier.
all right, upon examination, complaining witness. I find that the offenses charged were committed and there's probably cause to believe the defendant committed those offenses. And counsel?
Good morning, Your Honor. Christopher Shemke, bringing me up my client. This time we consent to the matter being heard via Zoom.
All right, and is Ms. Williams here? All right, Ms. Williams, name for the record, please.
Oh, Canisia Williams.
All right, and all right, counsel, as to the arraignment.
Wait, formal reading. My client stands mute.
It's on the second page. All right, the court will waive the formal reading. Ma'am, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
You spoke with the attorney today, right?
Yes.
All right. And you also understand that by entering into, or that you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on September 20th.
Yeah.
At the 28th District Court. And I'll ask you that.
Your Honor, my client currently lives in Lincoln Park with her mother. She has a strong family support system, no children, but is gainfully employed in 2 locations. My understanding is she's not on probation or parole, so we'd be respectfully requesting leniency when interpreting an appropriate bond, potentially consideration for a personal bond. Thank you, Your Honor.
Okay, and so where do you live, ma'am? In Highland Park?
Highland Park, Michigan, 31 Florence.
Okay, and who lives there with you?
That's my mother. She's legally blind.
Okay, and so legally blind, does that mean she can see with the assistance of
No, she can't see.
What's that?
No, she can't see.
Okay, and so who's with your mom right now?
Can you say it again?
Who is with your mom right now?
No one right now.
And so, who's Eleanor Shaw? Is that your mom? No, that's not your mom.
Is who?
That's the victim that owns the vehicle, Your Honor.
Yes.
No, my mom is Felicia Williams.
Okay, and so, where is it you work?
I work at Shake Shack, downtown Detroit, Michigan.
Okay, and where else? Don't you have 2 jobs?
Yes, it's a Great Lakes Renaissance. It's like a lawn company. We work for like CBS's, cutting the grass on CBS, like different companies.
Okay. And have you ever failed to appear in court? Have you ever failed to appear in court?
No.
Are you currently on probation from anywhere?
No. I got off the last one. I had paid it off. I got clearance for the class I had took, and I had to pay like $700 something. I paid it off like 2 months.
That was last month?
Yes.
And what were you on probation for?
I don't even know. They said that I attempted to take something from a store, but I didn't have anything. When they came out, they had ended up just letting me go. They had the right attorney at the time.
Would that be the matter from Green Oak Township?
Yes.
Okay.
When the officers checked me, I didn't have anything on me. I was doing the Instacart order, and my phone died. I was heading out to the car to plug my phone up, and the officer said,
I'm not looking for the facts of the case. I just want to know what the current status was. All right, Detective Esteban.
Your Honor, considering the nature of the offense and the defendant's action of putting officers in danger and potentially citizens of the city into danger with her actions, I'm going to recommend a $2,500 cash bond, Your Honor, and to reassure her next court appearance, Your Honor.
Well, the court's going to know, based upon the allegations, and what appears to be, what's alleged to be, have occurred, the court does find that there's a significant risk to the public, and the court's going to order the following bond. The court's going to order a $25,000 10% bond, to ensure the safety of the public, and that Ms. Williams is going to comply with the orders of bond to ensure the safety of the public. You're not to have any contact with Ms. Shaw. You're also not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to firearms and or any weapons. Do you have any of those?
No.
You're also not to operate a motor vehicle at all, whether you have a valid license or not. You're not to operate a motor vehicle based upon the charges in this matter. Or does not find that it is in the best interest of the safety of the public for you to operate a motor vehicle right now.
Okay.
Your Honor, was the PCC scheduled for the 20th of September? Is that what was scheduled?
Yes, September 20th at the 28th District Court. They're hearing our state docket that day.
Okay, thank you, Your Honor.
All right, thank you. Anything else?
No, thank you, Your Honor.
There you go.
Thank you. Have a good day.
Thank you.
In the matter of Brian Adams, 24654B.
Good morning, Your Honor. Chris Shemke, preparing on behalf of my clients. Time extends to the matter being heard via Zoom.
Okay, and Mr. Adams, your name for the record, please.
Brian Adams.
All right, today's the date scheduled for probation violation. You were sentenced on August 1st of this year. And at the sentencing date, you also had a bond violation hearing, which this court held in abeyance, as you did state that you used cocaine prior to July 17th, and the court did not have any levels to compare between the July 21st and July 23rd test. However, it's alleged you tested positive for cocaine on August 8th and August 22nd, failed to appear for drug testing on August 20th. And would it surprise you to know that we received the results of your September 1st test that showed positive also for cocaine?
Yes, Your Honor.
It would surprise you?
No, it would surprise me on that one, yes.
Interesting. Okay. All right. Cancel counsel?
Yes, Your Honor. I've advised my client that he has a right to have a hearing contesting these violations. That won't be necessary. He's prepared to admit responsibility.
All right, sir, please raise your right hand. You solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, and sir, you heard the allegations, correct?
Yes, Your Honor.
As to those allegations, how do you plead?
Guilty.
And you also understand the possible penalty as a result of your plea today, correct?
Yes, Your Honor.
And that the recommendation in this matter is for your probation to continue, you to complete all terms of probation, revoke your under advisement status, pay $50 probation violation fee, 15 days jail. Do you understand that?
Yes, Your Honor.
And knowing all that, do you want to continue with your plea?
Yes, Your Honor.
And anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No, Your Honor.
All right. And counsel, if you can please run your client.
Yes, like direct sections back to August 8th of 2024. Did you take a test which indicated the use of cocaine?
Yes.
Then did you fail to submit to a drug test as ordered on August 20th?
Yes.
And then a drug test taken on August 22nd indicated the use of cocaine. Is that accurate?
Yes.
Satisfied, Your Honor.
The court is also satisfied. Plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation and enter technical violations 1, 2, and 3. And counsel, as to the recommendation.
Your Honor, my client's 39 years old. He is gainfully employed. He is now living with his parents. He has a strong family support system. He indicated that he's very confident that his most recent test, or at least if he were to be tested, that he would be coming back clean. So I would be, as to jail time, asking for a jail review date so that we could see if cocaine is out of his system.
Well, sir, on August 1st, this court held your bond violation probation, your bond violation in abeyance. And then you continue to test positive for cocaine 3 more times.
Yes, Your Honor.
What gives?
I tried to go at this thing alone because I was embarrassed of what's going on. And I just tried to go at it alone with no support system or anything. So I had to get my family involved to help me get back on track and be the person that I know I am from this. I've never had to go through anything like this. So I was just embarrassed, and the only person I know was my girlfriend, and she doesn't do any kind of drugs or anything. So I got my parents, aunts, uncle, my old friend Adam Riley, whose dad's a pastor at Beacon Baptist Church, as a support system now to help me through this. I got my counseling all set up, which I'm supposed to go today, to try to beat this and do right and get this all behind me. And I'm sorry. I will do better, and I have to do better.
All right, here's what I'm going to do. What time is your appointment today, sir?
It is at 12:30.
Okay, so is that your intake appointment?
Yes, ma'am.
Okay.
And it's at GRMM on Maple and Wyandotte.
Okay. So what I'm going to do is I'm going to order you to continue and complete all terms of probation. I'm going to continue your under advisement status. Your under advisement status will be revoked for any future violations, sir.
Yes, Your Honor.
The court's going to order a $50 probation violation fee, and the court's going to order you to serve 15 days jail. You're going to serve 5. You're going to report tonight.
Is there any way I can report tomorrow so I can get work heads up?
You don't have time before 6 o'clock to do that today, sir?
Yes, ma'am. I will figure it out.
Okay. That way you'll start now and then you'll be out by the end of the week. So I'm going to order you to
I am
report.
so sorry, Your Honor. You broke up. I did not hear you.
You'll report tonight, sir, then you should be out by Saturday.
Okay.
So report today, I'm going to suspend 10 days. Sir, let that 10 days be an additional reminder to you, other than the 5 days that you're going to serve, to make sure you're complying with this court's orders.
Yes, Your Honor.
All right. Please email into Ms. Shaw, and she will get you set up with your, give you the information about reporting tonight.
Okay. Thank you very much.
All right, thank you. Have a good day.
You too.
All right, let's go off the record for a moment. Mr. Allison Thompson, 231962.
Good morning again, Judge. Paul Young on behalf of Ms. Thompson.
All right, and Ms. Thompson, your name please for the record.
Allison Blair Thompson.
All right, and so today is a date scheduled for the adjourned probation violation hearing, where it's alleged that Ms. Thompson tested positive for alcohol and THC on July 13th, and again tested positive for THC, which was an increased amount, on July 15th. And counsel?
We intend to tender a plea of not guilty, Judge.
Not guilty?
Guilty.
Oh, guilty, okay. All right, and ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, And you heard the allegations, correct?
Yes.
And as to those allegations, how do you plead?
Guilty.
You understand the possible penalty as a result of your plea?
I do.
And you understand the recommendation. The recommendation is for probation to be revoked, 5 days or 40 days jail plus the 5 days that were suspended. Do you understand that?
I understand.
Knowing all that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please state your claim.
As to the positive tests for THC and alcohol, can you give me the dates, Judge? Forgive me.
July 13th for the THC and alcohol, and July 15th for THC only.
On July 13th and July 15th, did you test positive for THC?
Yes.
And one of those days alcohol as well?
Yes.
Does that work, Judge?
The court is satisfied the plea is knowing, voluntary, and factually accurate. And just to confirm, you are on probation with this court for operating while visibly impaired, correct?
Correct.
All right, and that those are conditions of probation that you were not to use any alcohol or drugs, correct?
Correct.
Unless prescribed. All right, and neither one of those were prescribed.
Correct.
Okay. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea. Two of the violations indicate technical violations 3 and 4 will enter, and counsel, as to the recommendation.
I'm sure the court recalls that we were here on August 8th. When we started this, we got a jail review day, kind of adjourned all of this. Since then, she's done 5 days. She went from August 12th to 16th. And I believe that she's tested negative ever since August 8th. And I think you'll see 2 more negative results if the window of testing and reporting to this court as I believe it is. There were 2 tests, one on 9/8 and one on 9/9, that will in some short time in the future appear before this court as also negative tests. So I'm hoping that you will continue to defer any jail time and either give her another jail review date or just take these past 32/33 days as a positive and just put her back on probation. I hope you'll do anything but impose the 40 days.
Okay, so so let me just clarify a couple things. October 26th, Ms. Thompson was sentenced on her amended charge. On April 30th of 2024, she pled guilty to a probation violation. And this court ordered 10 days, suspend 5, and serve 5 days in jail. She served that 5 days, reporting May 6th. Then there was an additional probation violation. August 8th is when we held the jail review and the probation violation. And so this court, Ms. Thompson had entered a plea of not guilty on the violation, set up for hearing for today's date. The 5 days jail with the balance of the 5 days, the 10 days that had originally been suspended. And so as a result of the jail review, Ms. Thompson served the other 5 days jail. I just wanted to make sure procedurally that I made a record of that. And so Ms. Thompson, I think you can see that I'm not playing around. You had a high BAC, and that was amended to an operating while visibly impaired. And you kind of run the gamut: cocaine, alcohol, marijuana. It seems as though you're kind of dabbling in a little bit of everything. The cocaine were the 2 previous ones, I think, counsel, before you were on the case.
I was aware of them.
Okay.
Back on the case, you could say.
And, well, correct, yes.
Yeah.
And, so, ma'am, what gives? What gives? I mean, because you're prescribed medication from a doctor, correct?
I'm sorry?
You're prescribed medication from a doctor, is that correct?
I am, yes.
And so I'm presuming that neither one of those substances, whether it's the marijuana or the alcohol, is necessarily conducive to that medication. Right?
Right.
And so, what's going on?
The cocaine has been left in the past. As far as the lapse in judgment for drinking and using marijuana. There really is no good reason for it, Your Honor. There was my situation with my apartment and losing that apartment and having this whole change my lifestyle, but then again, it's not a good reason to use. It was a very silly lapse in judgment, and I want to let you know now that I understand that this probation is serious. What I did was dangerous, and there's just no good reason for me going back on that, but I hope that you can see my negative tests and see that I'm working to get this behind me and not commit this type of action again.
Okay, where's it you're working?
I work at a cuisine restaurant as well as the Whitney restaurant.
Okay.
I finished my undergrad at Wayne State July 30th.
Congratulations.
Thank you. Right now I'm practicing for my LSAT in order to take that test and continue on with more school.
I don't know why you want to take the LSAT, but good luck with that.
Be positive, Judge.
What's that?
I said be positive.
I know. It's definitely different than the LSAT itself is even different
Yeah.
from what it used to be, but when I took it, it was paper and pencil. Not anymore. I think it's online now. So, all right. So here's what the court's going to do. The court's going to order you to continue and complete all terms of probation. The court's going to order 40 days jail. I'm going to suspend that jail. I'm going to order mandatory revocation of probation and mandatory jail if there's one more violation. Okay?
Understood, Judge.
And that's based upon all of your tests being negative since your last court. The court will also note that you had some months of negative testing as well. So I'm hoping that you're going to continue with that negative testing. I'm also going to order you, are you already attending the fan meetings? Since you seem as though you don't know what I'm talking about, I'm going to go with no.
Assume not. Yeah.
So, I think it's called Face Addiction now. And I say I think because it used to be called Families Against Narcotics, but they stuck with the same acronym, and I think they're trying to inform people that it's for all substances for addiction, it's for any addiction. So that's why I think it says Face Addiction now. That's why it says that, because it's all, So, you'll get that information from Ms. Shine, so please have a seat over probation, and she will be with you shortly. Okay?
Yes,
Good luck to you, and have a good day. All right, let's go off the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Yeah. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.